Take those panels down, or we'll take your house.
That was what HOA President Vanessa Crowley told me while standing in my driveway, holding a violation notice that threatened to charge me $500 a day. My solar system had city permits, electrical approval, and clearance from the utility company. She knew that. She threatened me anyway. Then came the attorney fees, the lien warning, and the quiet little comments to my neighbors about how someone like me could no longer afford to live in a community like theirs. I didn't argue. I photographed the notice, saved every email, and opened a binder. Vanessa believed the fines would break me before anyone questioned her authority. What she didn't know was that one sentence in state law made her entire campaign dangerous. And buried inside the HOA's private records was an email she never expected me to see. Months later, that email appeared on a giant screen in front of the State Energy Commission. The moment the investigator read it aloud, Vanessa stopped smiling. But that day in my driveway, she was still completely certain she had already won. She hadn't come alone. 2 board members stood several feet behind her, along with a man wearing a reflective vest and carrying a camera. Vanessa introduced him as the HOA's safety inspector. When I asked for his license number, he lowered the camera and looked at her. Vanessa pointed toward my roof. "The glare is creating a safety hazard," she said, "and those panels violate our architectural standards." I went inside and returned with copies of the city permit, the electrical inspection, and the utility interconnection agreement. She barely glanced at them. "This community has higher standards than the city," she said. Then she pushed the notice against my chest. It gave me 72 hours to begin removing the system. After that, the HOA would start issuing daily penalties, with the amount increasing to $500 if I continued refusing to comply. I asked her to identify the exact rule I had violated. She tapped the clipboard with one manicured finger. "The board has already decided." That was when I noticed the date at the bottom of the notice. It had been prepared 3 days earlier, before Vanessa came to my property, before her so-called inspector took a single photograph, before anyone looked at my permits or gave me an opportunity to respond. This wasn't an investigation. It was a verdict written in advance. I asked Vanessa to confirm in writing that the board had reviewed my permits and still intended to fine me. She smiled as though the question amused her. "Put it in your little file." So I did. I photographed the notice before she left. I wrote down everyone who had been present, the time they arrived, and the fact that the punishment had been prepared before the supposed inspection. Vanessa thought she had handed me an order. What she had really handed me was my first piece of evidence. The solar panels weren't on my roof because I wanted to make a political statement. They were there because of my wife. Evelyn and I had lived in that house for 28 years. During the final winter of her cancer treatment, a storm knocked out power across the neighborhood for almost 12 hours. Her oxygen concentrator stopped. I dragged an old generator from the garage, fought with the frozen starter, and ran extension cords through the kitchen window while she sat beneath 3 blankets, trying to convince me that she was fine. She wasn't. A few weeks before she died, Evelyn left a handwritten note inside the folder where we kept our renovation plans. It said, "Someday, make this house capable of taking care of itself." 3 years later, I finally did. I replaced the aging roof, installed solar panels, and added a battery system capable of keeping the furnace, refrigerator, lights, and essential medical equipment operating during an outage. I followed every required step. The city approved the plans. A licensed electrician inspected the wiring. The utility company approved the grid connection. I also submitted the entire design package to the HOA months before construction began. They never responded. Not when I submitted the application. Not when the equipment arrived. Not while the contractors were working. They waited until the installation was complete and the utility company switched it on. 2 days later, Vanessa's white Lexus stopped outside my house. She didn't inspect the electrical equipment or ask about the permits. She stood in the street and stared from my roof toward the upstairs windows of her own home. Her property was being prepared for sale. That was when I began to understand what this was really about. Her problem wasn't safety. It wasn't architectural consistency. And it definitely wasn't the welfare of the community. It was the view from her own bedroom and how much she believed that view was worth. At the next HOA meeting, Vanessa didn't describe the panels as dangerous. This time, she called them destructive. She displayed a large photograph of my roof and told 30 homeowners that my solar system was lowering every property value in the neighborhood. Then she invited her real estate agent to speak. For 15 minutes, he warned that buyers expected visual consistency and that one unconventional roof could damage the community's premium image. When my turn came, Vanessa gave me 3 minutes. I placed my permits, inspection report, glare analysis, and utility approval on the table. The installation is legal, I said. What evidence do you have that it has lowered anyone's property value? Vanessa folded her hands. We don't need to wait for damage before protecting the neighborhood. I asked whether she had disclosed that her own house was being prepared for sale. The room went silent. For half a second, her expression changed. Then she struck the table with her gavel and accused me of turning a community issue into a personal attack. The board voted 4-1 against me. They imposed an initial penalty of $100 a day, with a warning that it would increase if I continued refusing to comply. As the residents began leaving, Vanessa approached me near the door. She leaned close enough that no one else could hear her. You'll remove them when this becomes too expensive. That sentence clarified everything. She wasn't trying to enforce a safety rule. She was trying to purchase my surrender using my own money. The following morning, I drove into town and bought 3 binders. I labeled the first one, Permits and Engineering. The second said, HOA Notices. The third was for everything Vanessa probably assumed I would forget. Dates, phone calls, meeting recordings, certified letters. Every time the board changed its explanation, I built a timeline beginning with the day I submitted the plans and ending with the moment Vanessa appeared in my driveway. Then I sent the board a written request. I asked for the specific architectural rule I had violated, the safety inspector's credentials, the glare report they claimed to rely on, and the minutes from the meeting where my installation had supposedly been reviewed. They sent me none of it. Instead, I received a 6-page letter from the HOA's attorney, Martin Vale. The letter demanded that I remove the panels, pay the accumulated penalties, reimburse the HOA for its legal expenses, and allow an inspection of my roof. It also warned me not to record any future meetings. That last demand told me they were becoming nervous. But something else caught my attention. The law firm's mailing address matched the address of a property company connected to Vanessa's husband. So I searched the state's public business records. Martin Vale wasn't merely the HOA's attorney. He was Vanessa's brother-in-law. According to the invoices attached to my account, his firm charged the HOA every time it sent me another letter. Vanessa wasn't only creating fines. She was creating customers. 2 days later, she called an emergency hearing and raised the price of resisting her. I received only 48 hours' notice. When I entered the clubhouse, Martin was already sitting beside Vanessa with a stack of documents marked confidential. Vanessa opened by calling my solar installation an ongoing safety emergency. I asked her to identify the danger. She mentioned glare, fire access, roof damage, and electrical risk, but she couldn't produce a single report supporting any of those claims. So I placed my phone on the table. For the record, I said, I'm recording this hearing. Martin leaned toward Vanessa and whispered something. Her language changed immediately. The panels were no longer dangerous. Now they were simply architecturally incompatible. I looked around the room. Did the safety emergency disappear when the recording started? Several homeowners laughed. Vanessa didn't. She announced that my refusal to cooperate proved ordinary fines were ineffective. Then the board voted to raise the penalty from $100 to $500 for every day the panels remained on my roof. $500 a day. $15,000 a month. And that didn't include legal expenses. Before I left, Martin handed me a new statement. It charged me for the hearing, his attendance, preparation time, and the certified letter announcing the increased penalty. They were billing me for the machinery they were using to punish me. But Vanessa had made a serious mistake. During the hearing, she abandoned every safety claim the moment a camera was running. And the next invoice revealed something worse. Martin's firm wasn't charging one flat fee. It was getting paid every time Vanessa escalated the case. By the third week, the notices were arriving faster than regular mail. There was a compliance fee, an inspection fee, a legal review charge, and a document preparation fee for letters that repeated the same threat with a different date. Every escalation created another invoice for Martin's firm. That was when my neighbor Elena Ruiz knocked on my door. She had seen Vanessa confronting me and wanted to know how much the HOA was demanding. When I showed her the statement, she went silent. 2 years earlier, Elena's husband had needed a wheelchair ramp after suffering a stroke. Vanessa called it an unauthorized exterior modification and buried them under the same kind of fees. Elena eventually paid almost $8,000 because her husband was too sick for a prolonged fight. She had kept every letter. The wording was almost identical to mine. Over the next few days, other residents quietly brought me their records. A garage door dispute, a garden shed violation, a warning over a work van, different homeowners, different alleged violations, the same law firm. I entered every payment and invoice into a spreadsheet. In less than 2 years, the HOA had paid Martin's firm more money for enforcement than it had spent repairing the neighborhood roads. Vanessa had approved nearly every invoice. I still couldn't prove that she was personally receiving money, but I could prove something else. The board wasn't using penalties to correct problems. It was using residents to generate legal fees. Then Martin sent the letter Vanessa believed would finally make me surrender. It said that if I didn't pay immediately, the HOA would begin the process of taking my home. 28 days after the first notice, they claimed I owed more than $14,000 in penalties and legal charges. Martin gave me 10 days to pay. If I didn't, the board would place a lien on my property and begin foreclosure proceedings. Vanessa delivered her own copy while Elena was standing beside my mailbox. She looked at my old truck and then at the work clothes I was wearing. People who can't afford community standards shouldn't live in communities like this. For the first time, I nearly lost my temper. Then I remembered something Evelyn used to tell me. Never interrupt someone while they're proving your point. So I photographed the envelope, wrote down the time, and added Vanessa's exact words to my records. That night, a summer storm knocked out power across the neighborhood. Within minutes, Elena called me. Her husband's oxygen concentrator had stopped, and their backup battery was nearly empty. My house still had power. The same solar panels Vanessa called dangerous were charging the battery in my garage. I ran a heavy-duty cable across the yard and kept the oxygen machine operating until the utility restored service. Vanessa's house remained dark for 6 hours. The following morning, she issued another violation notice. This one accused me of creating an unauthorized electrical connection between 2 properties. That notice became evidence number 37. Before I could place it in the binder, my phone rang. It was Thomas Reed, one of the board members who had voted against me. His voice was barely above a whisper. "Daniel, there's an email you need to see." Then he said something that changed the entire case. Vanessa knew the fines might be illegal before she ever raised them. Thomas refused to send the email electronically. He printed the entire message chain and met me behind the public library, 3 streets outside the neighborhood. The first message came from Martin. He had warned the board that state law might protect my installation and that a $500 daily penalty could be considered punitive. He recommended pausing enforcement until the HOA obtained an independent legal opinion. Vanessa replied 12 minutes later, "Keep the fines running. He'll run out of money before we run out of paper." I read the sentence twice. In another message, she wrote that once I was forced to remove the panels, no other homeowner would dare challenge the board. This was no longer about glare. It wasn't about safety, architecture, or property values. Vanessa knew the law might be against her. She continued because she believed the cost of defending myself would destroy me before anyone could stop her. Thomas admitted that he had remained silent because Vanessa controlled the board's contracts and had threatened to blame him personally for weakening the HOA. I thanked him, made 3 copies, and placed the original email chain inside a sealed envelope. I didn't confront Vanessa. I didn't post the emails online. I called Priya Shah, a property rights attorney whose name I found through a state energy advocacy organization. She spent 2 hours reviewing my binders without saying much. Then she placed Vanessa's email on top of the foreclosure letter. "This isn't just an architectural dispute anymore," she said. "This is evidence of deliberate financial coercion." She turned to the last page of Martin's warning. "And if the state sees this, the fines may become the smallest problem the HOA has." Priya didn't begin by sending Vanessa another threat. She converted my 3 binders into one formal complaint. We attached the city permit, electrical inspection, utility approval, meeting recordings, 37 violation notices, Martin's invoices, the foreclosure letter, the residence records, and Vanessa's private emails. Then Priya sent copies to the State Energy Commission, the Consumer Protection Office, and the HOA's insurance carrier. The insurance company reacted first. 3 days later, the board received a reservation of rights letter. It warned that the policy might not cover damages arising from intentional misconduct or undisclosed conflicts of interest. For the first time, Vanessa's decisions could cost the directors their own money. Thomas told me the emergency meeting that followed lasted almost 4 hours. 2 board members wanted to suspend the penalties. Martin advised them to negotiate. Vanessa refused. She said the state would never interfere with a private association. Then she accused me of using government agencies to intimidate the neighborhood. Finally, she announced a public meeting where the board would officially approve the lien against my home. She wanted the residents to watch me lose. When I entered the clubhouse that evening, Vanessa was already seated beneath the HOA banner, smiling beside Martin. She didn't notice Priya take a seat in the front row, and she definitely didn't recognize the 3 people sitting beside her. Vanessa struck the gavel and began reading the motion to record a lien against my property. Before she reached the second paragraph, one of the strangers stood. "Mrs. Crowley," he said, "you need to stop this meeting immediately." The man introduced himself as an investigator with the State Energy Commission. The woman beside him represented Consumer Protection. The third was from the agency reviewing the HOA's financial records. Vanessa stared at them as though they had entered the wrong building. "This is a private association meeting," she said. "You have no authority here." The investigator placed a folder on the table. "We have authority over the complaint filed against this association. Effective immediately, you are required to preserve every email, invoice, meeting record, and enforcement document connected to Mr. Mercer's case." Martin stopped writing. The investigator continued. Any attempt to collect the disputed penalties, record a lien, or alter relevant documents may create additional liability. For the first time since the conflict began, Vanessa looked uncertain. Priya stood and asked whether Vanessa had disclosed that Martin was her brother-in-law before approving payments to his firm. Vanessa called the question irrelevant. Thomas opened the official meeting minutes. "There is no disclosure," he said. One board member pushed her chair away from the table. Another announced that she was resigning, effective immediately. The room erupted. Vanessa struck the gavel repeatedly, shouting that the state could not tell the HOA how to govern its own neighborhood. The investigator waited until the room became quiet. "Mrs. Crowley," he said, "you'll have an opportunity to make that argument under oath." 6 weeks later, she did. And that was when Martin was forced to answer the question Vanessa had spent months avoiding. The state hearing room looked nothing like Vanessa's clubhouse. There was no HOA banner behind her, no gavel in her hand, and no group of directors waiting for permission to speak. She sat at a narrow table beside Martin, while 3 commissioners reviewed the evidence on screens above them. The first witness was Marcus Lee from the utility company. He confirmed that my installation had passed every required inspection. The wiring complied with code. The fire setbacks were correct. The grid connection had been approved before the panels were activated. One commissioner asked whether the system created a glare hazard. Marcus displayed the engineering report. "No," he said. "The measured reflection is lower than the reflection from several windows already approved in the same neighborhood." Then the commission played clips from the HOA hearings. In the first recording, Vanessa called the panels an electrical emergency. In the next, she called them an architectural problem. In another, she claimed they threatened property values. The commissioner paused the video. "Mrs. Crowley, which of those was the actual basis for the penalty?" Vanessa said all of them. The commissioner asked for the HOA's independent safety report. Martin admitted there wasn't one. Then the screen changed. Vanessa's email appeared in letters large enough for everyone in the room to read. "Keep the fines running. He'll run out of money before we run out of paper." Vanessa stopped smiling. The lead investigator asked Martin whether he had warned the board that state law might protect my installation. Martin looked toward Vanessa. The investigator repeated the question. "Yes," Martin said. "Did you recommend pausing enforcement?" "Yes." "Did the board continue issuing penalties?" Martin swallowed. "Yes." The next exhibit showed his invoices. Every violation notice generated a legal charge. Every emergency hearing produced another bill. Every escalation Vanessa approved sent more HOA money to Martin's firm. The investigator asked Vanessa whether she had disclosed that Martin was her brother-in-law before voting on those payments. She said everyone on the board already knew. Thomas was called next. Under oath, he said they did not. He described how Vanessa controlled the meeting agendas, pressured directors to approve invoices, and warned that anyone opposing her would be blamed for weakening the HOA. Then Elena testified. She brought the letters from her husband's wheelchair ramp dispute and placed them beside mine. The wording was almost identical. The same threats. The same accumulating charges. The same law firm. By then, the hearing was no longer about one roof. It was about a pattern. Priya closed our presentation by placing Evelyn's handwritten note beside the foreclosure letter. One was a promise to make a home safer. The other was a threat to take that home away. I didn't ask the commission to punish Vanessa because she had insulted me. I asked them to decide whether an HOA could knowingly use financial pressure to erase a right protected by state law. The commissioners left the room to deliberate. Vanessa whispered angrily at Martin. Martin didn't answer. Nearly an hour later, the commissioners returned. The chairwoman said they had reached a decision regarding the penalties, the threatened lien, the legal expenses, and the board's conduct. But before she announced it, an attorney representing the HOA's insurance company stood up. He handed the clerk a separate letter. The chairwoman read the first page, looked directly at Vanessa, and asked, "Mrs. Crowley, were you aware that your insurer had reserved the right to deny coverage for intentional misconduct?" Vanessa turned toward Martin. This time, he wouldn't look at her. The chairwoman began with the simplest part. Every penalty against me was void. The HOA had violated state law by using its architectural rules to effectively prohibit a legally approved solar installation. The daily fines, inspection charges, hearing fees, and legal review expenses had no lawful basis. The lien was ordered removed immediately. Then she moved to the part Vanessa hadn't expected. The commission found that the board had continued enforcement after receiving a written warning from its own attorney. Vanessa's email proved that the purpose of the penalties was not compliance. It was financial pressure. The HOA was ordered to reimburse my legal expenses, compensate me for costs caused by the threatened lien, and pay administrative penalties for intentionally interfering with protected energy rights. The total came to just over $150,000. A sound moved through the room, not quite a gasp and not quite a whisper. Vanessa leaned toward Martin. "You said insurance would handle this." Martin stared at the table. The insurance attorney stood again and confirmed that the policy would cover only a limited portion of the defense expenses. It would not cover administrative penalties or damages arising from conduct the commission had found intentional. The money would come from the HOA's legal reserve. The same reserve Vanessa had spent years claiming was necessary to protect the neighborhood. It was nearly wiped out in a single morning. The commission also referred the undisclosed family relationship and vendor payments for additional review. Vanessa was ordered to take no part in HOA contracting or enforcement while that review continued. She resigned 3 days later. Martin's firm was terminated the same week. At the next community meeting, nobody sat beneath Vanessa's nameplate. It had already been removed. A financial report appeared on the screen behind the new board. Legal loss, $150,000. Elena sat beside me holding the letter that officially erased the penalties from her husband's wheelchair ramp. The new board reviewed similar cases and refunded residents who had been charged through the same abusive process. They also passed new rules. No director could vote on a contract involving a relative. Major penalties required independent legal review. Residents could record their own hearings, and no architectural rule could override a right protected by state law. A year later, the HOA installed solar panels on the clubhouse. They asked me to inspect the plans. I agreed on one condition. Beside the new battery system, they mounted a small plaque. It read, "Community standards should protect people, not control them." That evening, I went home and placed the commission's decision inside the final binder. Then I found Evelyn's handwritten note. "Make this house capable of taking care of itself." I looked through the window at the battery indicator glowing green in the garage. Vanessa had tried to use my home as an example of what happened when someone challenged her authority. Instead, it became an example of something else. A clipboard can frighten people. A fine can pressure them. A threat can even make them doubt what they know is right. But none of those things can survive a law someone finally reads, a record someone refuses to lose, and a homeowner who decides not to surrender. So let me ask you this. What would you have done when that first $500 threat arrived? Would you have removed the panels to protect your home? Or would you have kept every notice and forced the board to prove its authority? Tell me in the comments, especially if you've ever dealt with an HOA that cared more about control than the people it claimed to represent. And remember, the loudest person in the room doesn't always hold the real power. Sometimes, real power is a permit, a saved email, and a binder nobody expected you to keep. Subscribe for more stories where quiet homeowners let the evidence speak for them.